First and foremost, I object to the utter and blatant lack of transparency in the approval process. The proposed revision before us today represents a major shift in the advice we have given the American public for the last 22 years. Yet we are about to approve this dramatic shift in our interpretation of the rights of job applicants and the obligations of America's businesses under Title VII without ever circulating it to the American public for review and discussion. There is absolutely no justification for totally excluding the American people from this process or for this blatant failure to be transparent in how we conduct our business. I am devoted to the issue of civil rights and to the work of this commission. But if we vote to approve this guidance today, how can we expect American people to have confidence that this agency operates openly and with full transparency? We are public servants. We work for the American people. What could possibly justify keeping them from knowing what is in this document before we approve it? This particular proposed new guidance, which in reality is a kind of regulation, has tremendous implications for Americans. It is exactly the type of policy shift that we should share with the American people. Ask them to take a look. Tell us what they think. Have we forgotten anything? Have we explained things well, or is it confusing? And most importantly, how will this impact you? But we didn't do that. Instead, the document was rapidly brought to a vote without the American people ever having a chance to see what was in it. That is just plain wrong. There are people in the commission room today and throughout America who have considerable expertise in the subject the guidance addresses. Yet we are about to give final approval to this draft without ever letting any of these experts or the public at large see a single word that it contains. And we are approving it without even bothering to submit it to OMB for their expert review. That begs the question, why? Why don't we want America to see what's in this document before we make it final? We should have spent months reviewing and discussing this with the public, as we have other regulatory and sub-regulatory documents. Yes, the Commission did have a meeting on background checks and did hear from stakeholders on the general subject of the pros and cons of conducting criminal background searches. But seeking general input is a far cry from sharing what is actually in the actual proposed revised guidance. As soon as the revised guidance was drafted, the public was shut out. Here is my second concern. It is my understanding that the Senate Appropriations Committee, Subcommittee on Commerce, Justice, and Science, the committee that determines our funding year to year, under the direction of Chairman Senator Barbara Mikulski and Ranking Member Senator Kay Bailey Hutchinson, in the report attached to the appropriations bill, specifically addressed their concerns about the haste with which this commission was proposing to approve changes to the current criminal background checks guidance, and specifically instructed the commission to A, engage stakeholders in discussion about the intended changes to the criminal background checks guidance, and B, circulate any proposed changes to the guidance for public input for at least 6 months before bringing it before the commission for a vote. When the Senate Appropriations Committee, the committee that controls our funding, attaches to the bill that will determine our funding specific instructions to hold off taking any action on this revised guidance until we have circulated a copy to the public for input for at least 6 months. It seems to me we should take that seriously. So why is this even on the agenda today? Are we seriously going to ignore this directive from the Senate committee that decides our funding? Especially when, and here's the irony, there is absolutely no need to take any action on this today or any time in the immediate future. What is the big rush to approve this guidance? What would justify ignoring a Senate Appropriations Directive and ignoring our obligation to be transparent with the American people? There have been no changes in Title VII, no new Supreme Court decisions that would compel a single change to our current guidance. In contrast, our guidance on the use of arbitration agreements in employment contracts has been out of date and a misstatement of the law since the first Supreme Court decision on that subject in 1991. As far as I know, there's no effort being made to circulate any revision of that guidance or bring it before the Commission for a vote. Thirdly, I object to the guidance because it so obviously exceeds our authority as a regulatory commission. We are an enforcement agency. We have the authority to issue, amend, or rescind suitable procedural regulations. We have no authority to make substantive changes in the law by issuing guidances that go beyond what is contained in the statutes as interpreted by the courts. Our job is to follow congressional intent and court interpretation, not make new law. No matter how well-intentioned we may be, no matter how much a change in the law may be warranted, we simply lack the authority to make those changes through the issuance of guidances. It is Congress's job, not ours, to weigh the pros and cons of proposed new legislation and approve or disapprove it. We are not Congress. We are not part of the legislative branch, and it is the job of the courts to interpret the laws that Congress passes. We are not the courts. We are not part of the judicial branch. Our job is to explain what is already the law, not to expand it. No matter how much some of us may want Title VII to provide additional protections, we cannot use our authority to issue guidances to create new rights and protections that Title VII does not provide. If we think Title VII should be expanded, we should make our concerns known to Congress, not take it upon ourselves to do Congress's job. Finally, I oppose the guidance because of the real impact it will have on America's business. Last night, I tried and read the guidance as a business owner would read it. What I came up with over and over again was that if I were a business owner, no matter what business I was in, I would never again conduct another criminal background check on a potential employee unless I were required to under federal law. Not just state law, but federal law. I understand all of the well-intentioned reasons for drafting the revised guidance, but I question whether it will achieve what it attempts to achieve. I'm afraid the reality is the only real impact the new guidance will have will be to scare business owners from ever conducting criminal background checks. Thus, the unintended consequence will be that even those business owners who we all agree should conduct criminal background checks simply will not. Why should they? The guidance tells them that they are taking a tremendous risk if they do. The guidance tells them that even if they are not discriminating, if they are treating all races and ethnicities equally, they could be found guilty of unintentional discrimination under a disparate impact theory. All this new guidance does is to put business owners between a rock and a hard place. Conduct criminal background checks to protect your employees and the members of the public you serve, and you bear the risk of having to defend your action as discriminatory. Don't conduct the background checks, and you take the risk that an employee or a member of the public will be harmed. This is no help to America's business owners. In summary, I object to the utter lack of transparency in the development of this guidance. I object to the inexcusable way the public has been intentionally shut out of this process. I object to the unnecessary haste to which this document has been pushed through, and I object to the burden it places on business owners. I strongly oppose the guidance and will vote against it. Thank you.